Hi, everybody. Welcome back. My name's Blinn.
I'm Michael.
We're Woods and Bates, and today we're going to talk about wills. Whether or not you know it or not, August is National Make a Will Month.
Well, I think I ought to do that. I just got married, even though that's no excuse to waiting to make a will, but it's a good life-changing event to make somebody go out and contact an attorney and get that document started. So why don't you talk about what happens if you don't have a will?
Well, there's a lot that happens if you don't have a will. Mainly, we look to the statutes of the state of Illinois to see who has preference to act as the administrator of your estate and where your assets are going to go according to those rules. So let's take you as an example, since you apparently don't have one yet. If you didn't have a will, who do you think would get your assets?
In my mind, my assets would go to my family. Now, my family, under the eyes of the Illinois law, says that would be your spouse and then your heirs at law. So my heirs at law, I currently do not have any children, so my heirs at law would be my parents and my siblings, my grandparents. You go up the ladder. So if I passed away today, half of my estate would go to my spouse, half of it would go to my heirs at law. So who would get my property today?
If you died today without a will, the state of Illinois says that your wife would get everything.
100%.
100%. So it goes to a surviving spouse and descendants or children of the surviving spouse. So if you had kids, it would go half and half. If there was no surviving spouse, but you had children, the entire estate would go to your children. If there is a surviving spouse but no children, the entire estate goes to your children. And then from there, if there's no surviving spouse or children, it would go to parents, brothers, sisters, or descendants of a brother or sister. And if you don't have any of those, it gets even more complicated. But if you had a will, you could say exactly where you wanted it to go. There's rules about people that you cannot disinherit totally. So, I mean, the law looks out for spouses in Illinois. It looks out for minor children. It looks out for dependent disabled children, things like that. But one of the things you could also do in your will is you could nominate an executor, which would be the person that would gather up your assets when you're gone and distribute those assets. So who do you think, if you didn't have a will, would be entitled to act as your administrator of your estate?
So that, according to the laws of the state of Illinois, would be my wife. Is that correct?
That's correct.
Surviving spouse would have the preference to act as the administrator. So an executor is somebody that's acting under a will that a decedent creates. You get to appoint your executor. An administrator is somebody that the court appoints, and that individual would act if you don't have a will. So currently, without a will in place, my administrator would be my spouse. Now, say if I didn't have a spouse and I didn't have children, who would be authorized to act as my administrator?
So let's see. Then it would go to your grandchildren, which you don't have, and then it would go to your parents. And any of those people that have preference could also either act or nominate somebody to act. So if you had a surviving spouse, they wouldn't necessarily have to act. They could nominate somebody else to act if they wanted to. They would have that preference. But if you had no surviving spouse, no children, no grandchildren, your parents would be the ones with preference. Then from there, you would look to brothers and sisters if you had no parent living, and it would go kind of on down the line from there. But
so if I have two parents surviving me, no spouse, no children, no grandchildren, would my mom or my dad have preference to act as administrator?
They would have equal preference. So they would either have to argue over who's going to act or decide amongst them that they're going to act together. And that's kind of one of the reasons why an executor nomination is important, because it gets rid of all that uncertainty. You know, you nominate who you want to do the job, and there's not a whole lot of argument from that point. And kind of the same goes with guardians for minor children. You can nominate guardians for minors in your will. If you don't have that nomination, people may argue over who's going to do it. I don't know if there'll be a lot of people banging down the door to take care of minors, but some might.
I think that would come up when you don't have children, you don't have a surviving spouse, you don't have children, you don't have grandchildren. So going up the ladder, you go to your parents first. Let's say you have no surviving parents, but what you do have is 4 or 5 siblings surviving you. Now, some families don't get along as well as others, so of those 4 or 5 siblings, they would have to ask the court who has petition the court to act as that administrator and make the argument why they should be entitled to act as opposed to one of your other siblings. So again, that situation where somebody comes in and wants to be guardian for minor children, aunts and uncles might have pretty close relationship with their nieces, nephews, and maybe they each want to act as those guardians, and without a will in place nominating certain guardians of the estate and person of those minor children could lead to an unhealthy legal battle between siblings. As they're also grieving over your death, they are also now battling who gets to take care of their nieces and nephews. So August National Make a Will Month, I would strongly advise it. Amanda, we're gonna have to do one soon.
I think one of the other things that I can think of that just off the top of my head that would be an advantage of having a will versus not having a will is the bonding requirement that you can waive for your personal representative of the estate in a will. If you don't have a will, then that administrator has to get a bond, whether that's a corporate bond or private bond with sureties, which would be 2 people that would be guaranteeing the performance of the administrator, and that has to be in an amount of double the amount of the personal property of the deceased. So there's a cost associated with that if it's a corporate bond, and you have to try to convince a couple people to vouch for you if it's a private surety, and depending on the value of the assets, they may or may not be willing to do that if you are not trustworthy. But it's always a good idea to put your intentions in writing, and we would certainly be willing to help discuss that. I think it's also a good time of year to take a look at what you may have as far as a will goes, and could always be time to update that.
Yeah, that's something that we have individuals come in here frequently. They come in, they say, we have a will in place. It's from 1996. And my first question to them is, well, have things changed since then? And when things change, maybe you need to update that will to maybe a minor child was receiving assets in a trust under that will. Well, now that child is 35 years old and no longer needs a trust to administer those assets. So there's no rule of thumb as when to update your will, but usually when there's some type of significant change in circumstance, it's good to go in and get that updated as soon as possible. I do a lot of divorce work. That's one of the first things I tell my clients whenever a divorce is finalized. Make sure you update that will. If something happens in the interim between finalizing a divorce and some type of judgment for dissolution of marriage getting entered, if you passed away in that time frame and you didn't have a will, or even if you do have a will leaving everything to your spouse, your ex-wife or your ex-husband is now going to get not only half of the marital estate, but all of your estate. So anytime there's a real change in circumstances in your life, whether you get married, get divorced, have kids, have grandchildren, it's always a good time to review your will and update it if need be.
Probably not a lot of divorced people really want their ex-spouse to get their entire estate, do they?
I don't see it very frequently.
All right, well, thanks for joining us, and we will see you next time.
Thank you.